In this lecture, we shall continue with our discussion on the interests that can be held in land in Ghana. The interests that can be held and registered in respect of land in Ghana. You remember that in our previous lecture, we indicated that under Section 1 of the Land Act of 2020 at 1036, 6 interests have been indicated as the interests that can be held in land in Ghana. And these 6 interests are the allodial title, the customary law freehold, the common law freehold, the usufructuary interest, the leasehold interest, and customary tenancy. Customary tenancy. Remember that in our previous lecture, we also referred to Section 81 of the Land Act, which indicates that these various interests that we have mentioned in Section 1, they are registrable interests under land law in Ghana. And so when you look at Section 81 of the Land Act, it says the interests in land which are registrable include allodial title, common law freehold, customary law freehold, usufructuary interest, leasehold interest, and customary tenancy. So 6 interests are the interests which are registrable in land in Ghana. Now, out of these 6 interests which can be held in land in Ghana, you remember in our previous lecture, we discussed 3 of them. We discussed the allodial title, which under Section 2 of the Act 1036 is the highest interest which can be held in land in Ghana, and the allodial interest can be held either by the states or the stool or skin or clan or family or an individual. And then we also dealt with the customary law freehold, which we said is an interest in land which arises from a transaction under customary law. We mentioned that the holder of the customary law freehold owes no proprietary obligations to the holder of the allodial title, and that the holder of the customary law freehold holds is subject to the jurisdictional and cultural rights of the allodial title holder. And we mentioned that the holder of the customary law freehold is one that acquires an interest which is of perpetual duration, which is inheritable, and which is alienable without the consent of the holder of the allodial title. So we dealt with the allodial title holder under Section 2, we dealt with the customary law freehold under Section 3, and then we dealt with the common law freehold under Section 4. And under the common law freehold, we mentioned that it is also an interest in land. It also arises from a transaction. And this transaction is one that is governed under the rules known as the common law. And then this common law freehold is also held free from any obligations to any other person. And we mentioned that this common law freehold also is of perpetual duration, it is inheritable, and it is alienable. We mentioned that this common law freehold too is subject only to the jurisdictional and cultural rights of the stool, the skin, clan, or family which holds the allodial title. And remember, we do a distinction between the common law freehold and the customary law freehold. And we mentioned that the cardinal distinction is that the common law freehold arises from a transaction that is governed under the common law. And then we also look at the 3 different categories of common law freehold that we can have. We mentioned and we explained the common law, the customary law, the common law fee simple. We look at the freehold and the life estates. So in our previous lecture, we discussed these three interests: the allodial title, customary law freehold, and then the common law freehold. In this lecture, we shall proceed to discuss the remaining three interests that have been mentioned under section 1. And these remaining three interests are the usufructuary interests, the leasehold interests, and then customary tenancies. Customary tenancies. So we shall begin with the usufructuary interests. On the usufructuary interests has been explained under section 5 of the Land Act of 2020 Act 1036. Now, before I read out section 5 of Act 1036, I want to give you a key and some guidance to really appreciate and understand the usufruct that has been mentioned under section 5 of the Land Act of 2020 Act 1036. Under section 5, there are two categories of the usufruct. We have a subject usufruct and we have a stranger usufruct. So section 5 gives two categories: the usufruct that can be acquired by a person who is a subject of the stool or skin or family or clan, and then it also gives an indication that the usufruct can be acquired by a person who may not be a subject or who may not be an indigent. So as I proceed to read section 5 of Act 1036, be on alert and see how section 5 explains usufruct under these two headings. So I shall now proceed to read out section 5, subsection 1 of the Land Act of 2020, Act 1036. Section 5, subsection 1 reads as follows, and I quote: "The usufruct is an interest in land, which is A, acquired in the exercise of an inherent right by a subject or a member of a stool or skin or family or clan, which holds the allodial title through the development of an unappropriated portion of the land, of the stool or skin or family or clan, or by virtue of an express grant, or acquired through settlement for a period of not less than 50 years, with the permission of the holder of an allodial title, by a non-indigent or group of non-indigents, or the descendants of a non-indigent or group of non-indigents, except where the settlement is on agreed terms and is inheritable and alienable." Now, having read out section 5, subsection 1, let us go and now proceed to discuss and see how we can distill the cardinal elements or characteristics of the usufruct as embodied in section 5, subsection 1. Remember, I had already mentioned that section 5 creates a situation whereby you can have a usufruct acquired by an indigent and the other that can be acquired by a stranger or non-indigent. So what can we know from section 5? Now, under section 5, there's one way of acquiring the usufruct by a subject. And that is what you see under section 5, subsection 1A. And over there, these are the points that we can note. That's one. A usufruct is an interest in land. And that this interest in land can be acquired by a subject or a member of a stool, skin, clan, family, or an individual or groups which hold another title. So first, the usufruct is an interest in land, and it can be acquired by a subject or a member of the person holding the another title. Again, under section 5, we see that if it is the subject that is acquiring the usufruct, the person must be exercising his inherent right as a subject. Inherent right as a subject to develop an unappropriated portion of the land of two, skin, or family or clan land. Or the subject must have acquired the usufruct through an express grant. So what we see under section 5, subsection 1A is that the usufruct is an interest in land, and it can be acquired by a subject. But when the subject is acquiring the usufruct, there are two ways the subject can acquire it. The subject can acquire it through the exercise of its inherent right as a subject to develop an unappropriated portion of the land. So the subject can acquire the usufruct by exercising his inherent right as a subject to develop an unappropriated portion of the land that belongs to the allodial title that he is a member of. So either the subject can acquire it by exercising his inherent right just to go to any undeveloped or uncultivated portion and cultivate it, or the subject can acquire it by an express grant from the stool that holds an allodial title. So either you go and look for any undeveloped portion, reduce it into your possession, and cultivate it. You would have acquired the usufruct. Or if you don't want trouble, you can go straight to the allodial title holder and tell him to give you an express grant of the land. Since you are a subject, what you acquire is a usufruct. And you are told that it is inheritable and it is alienable. It's an interest that you can transfer. So this is the first mode of applying the usufruct under section 5, subsection 1A. This is an acquisition by a subject. And like I was saying, the subject can acquire it by exercising his inherent right just to go to any uncultivated portion, cultivate it, and reduce it into his possession. He would have acquired the usufruct. But the subject can go and ask for an express grant from the stool or skin or clan, as the case may be. Now let's go to the second mode of acquiring the usufruct. As we can see from section 5, subsection 1B. And for clarity, I shall read the section 5, subsection 1B before I now give the points that we can note. Section 5, subsection 1B reads as follows, and I quote: the usufruct is an interest in land, which is acquired through settlement for a period of not less than 50 years, with the permission of the holder of an allodial title by a non-indigent or group of non-indigents or the descendants of the non-indigent or group of non-indigents, except where the settlement is on agreed terms and it is inheritable and alienable. So these are the points we can note from the second mode of acquiring the usufruct by a non-indigent. First mode, first point to note is that This mode of acquisition is available to strangers or non-indigents of the holder of the allodial title. Strangers or non-indigents. Now, how do they acquire it? Now, the non-indigent or the stranger can acquire the land through settlement for at least 50 years with the permission of the holder of the allodial title. So if you seek the permission of the holder of the allodial title, and you've been there for at least 50 years, then we can say that you have acquired the stranger usufruct. And note that this is not adverse possession, where you have occupied land in a way which is adverse to the owner for a period of 12 years or more. No. Over here, you occupy the land with the permission of the holder of the allodial title. Then you have been there for at least 50 years. The law says that you have acquired the stranger usufruct. And for this one as well, it is also inheritable and it's also alienable. Now, this is also one point that we must also note. When we say it is inheritable and it is alienable, what do we mean by that? If you say it is inheritable and alienable, it means you can transfer it either to your descendants in your will, or you can transfer it in your lifetime. But let me point out to you that the Act draws a distinction in the way and manner in which you can alienate the usufruct, depending on whether it is a subject usufruct or the stranger usufruct. Now, what the law says is that if you are the subject and you want to transfer, as for that one, you can go ahead and transfer your land in any way you like without even seeking the consent of the holder of the allodial title. But if you're the stranger usufruct and you want to transfer, for that one, you must seek the written consent of the holder of the allodial title. And that is what you see under section 5, subsection 2b. And so now let me read it out to you so that I can highlight on the essential aspect that brings out these points. So I'm reading section 5, subsection 2b of the Land Act of 2020 at 1036. And it reads as follows. Where the alienation of the usufruct is to a person who is not a non-indigent, or from the group of non-indigents who hold the usufructuary interest as provided in paragraph B of subsection 1, in the land in respect of which the usufruct is to be alienated, the alienation is subject to the written consent of the stool or skin or clan or family or group and the performance of established customary obligations. So today, when you have a non-indigent who has settled on land that belongs to the allodial title holder, and they settled on the land with the consent of the allodial title holder for at least 50 years, such a person is now recognized by law to be a holder of a usufruct, having the power to alienate and dispose of the land by way of inheritance. So we have two categories of the usufruct. The one that is available to a subject who is exercising his inherent right under customary law to reduce any unconsolidated land into his possession and cultivate him. And we have the usufruct that can be acquired by a stranger who has settled on the land for at least 50 years with the consent of the holder of the allodial title. In relation to the subject usufruct, let me mention that all the cases we have that deal with subject usufructs, like the case of Mansu versus Aboye. Mansu is spelled M-A-N-S-U versus Aboye, A-B-B-O-Y-E. Reported in 1982-83, Ghana Law Reports at page 1313 and page 1321 remain applicable to the subject usufructs. And for those of you who are not aware of this case, we shall deal with these cases into detail when we deal with the incidents of a usufruct. But at this point, permit me to just read out a portion of the dictum of Aban J.E. in this case of Mansu and Aboye, so that you can have an idea of how powerful the usufructuary holder is. Some of you by now will be thinking that if a usufructuary holder, all he has to do is just reduce any uncultivated land into his possession. Some of you will think that then it means he will not acquire any strong rights. But if you read Mansu and Aboye, you will see that the law has been held that when a subject has acquired the usufructuary interests by reducing an uncultivated land into his possession and developing same, in fact, he acquires it, he holds it forever, and the allodial title holder cannot even re-enter the land or cannot even give the land to a third party without seeking the consent of the usufructuary holder. That is how powerful the usufructuary holder is. The moment you are a subject and then you see a land which has been uncultivated and you reduce it into your possession, you acquire the usufructuary interest, you acquire it and it is potentially perpetual, and you can alienate it, and the allodial title holder cannot re-enter or even alienate it without seeking your consent. This is what Aban J said in the case of Mansu versus Aboye, and I quote, "The plaintiff, as a usufructuary owner, cannot be ousted from the land by the co-defendant in an arbitrary manner. Some of the cardinal incidents of the usufructuary interest are that the usufructuary has exclusive possession and enjoyment of his portion of land, and he cannot capriciously be divested of his interests by the stool. Neither can the stool alienate that portion of the land to any other person without the prior consent and concurrence of the usufructuary owner. The allodial owner, without the permission of the usufructuary owner, has no right to the economic trees on any land which is in the possession and control of the usufructuary owner, whether those economic trees were cultivated or grew on the land without the intervention of human labor." Quote ends. So what are they telling us over here? That once a person has acquired a usufructuary interest, then the holder of the allodial title cannot even transfer the land to a third party without seeking the consent of the holder of the usufructuary interest. That is how powerful the holder of the usufructuary interest is. So for those of you who are thinking that it doesn't make sense that you say a subject will just go and look at any uncultivated land, reduce it into his possession and cultivate, we are being told in Mansu and Aboye that once the subject has reduced land into his possession, then it's a cardinal feature of the usufructuary interest that the subject has exclusive possession of that land and he cannot be arbitrarily divested of the land by the holder of the allodial title. Apart from Mansu and Aboye, let us also look at the case of Ohemin versus Ejay, reported in 1957, West African Law Reports at page 275, specifically at page 279, where the learned judge delivered as follows, and I quote: the stool holds the absolute title in the land as trustee to and on behalf of its subjects, and subjects are entitled to the beneficial interests or usufruct thereof, and have to serve the stool. Each individual or family is regarded in the broad sense as the owner of so much of the land as it is able by its industry or by the industry of its ancestors to reduce into the lawful possession and control. The area of land so reduced into lawful possession of individual or family, and over which he or they exercise a usufructuary right, usually called his property. It cannot, save with the express consent of the family or individual, be disposed of by the stool. The individual or family may assign or dispose of his interests in the land to another subject of the stool, and the land may be sold in execution of a decree against the individual or the family, as the case may be, without the consent of the stool. But he may not dispose of the stool's absolute ownership in it to a stranger without the consent and concurrence of the stool. Quote ends. So what are we told in Ohimi and Ejie as well? We are told that once a subject reduces a portion of uncultivated land into his possession, then he can call that portion his property. Now, apart from seeking his consent to, the holder of the allodial title to cannot deprive that subject of his interest in that particular land. Once you reduce an uncultivated land into your possession, then it becomes yours. You acquire the usufructuary interest. That is what we are all told in Ohimi versus Ejie. And then to drum home the point well about this subject usufruct, let me nail it with a case also of Norquay Tete versus Malm. Norquay is spelled Norquaye hyphen and then Tete versus Malm. Malm is spelled Malm and another. Reported in 1959 Ghana Law Report at page 368. Norquay Tete versus Malm. This is what the court also said, and I quote: by customary law, a stool cannot make a valid grant of any portion of its land on which there exist economic trees like mango and cashew. This is a well-established custom which is based upon another very sound customary law, namely that any subject of a stool is entitled to occupy a vacant portion of the stool land and to become the owner of the usufruct thereof. His occupation and possession may be by cultivating it in one form or another, by building on it, or using it in any other way in which an owner would use his land. A subject in such possession may alienate that possessory title of his, either to another subject or to a stranger, or he may lease it, so long as such alienation or lease carries with it the obligation to recognize the allodial ownership of the stool. By custom, a stool cannot alienate its absolute title in such a portion of the stool land without reference to the subject or the grantee in possession. And the quote ends. So what are we being told to inaugurate and mom? That if a subject has moved into a vacant portion of stool land, and the subject has exercised his inherent right to plant economic trees, the presence of the economic trees is evidence that somebody has expended his labor on that particular land. And it means that if that person is a subject, he would have acquired a usufruct. And if he acquires the usufruct, you, the allodial owner, you cannot come and remove him from there without seeking his consent. That person acquires a usufruct which he can transfer either in his lifetime or to his descendants. So let us now come back to section 5 of the Land Act, which explains usufructs. You remember under section 5, we were told that the usufruct can be acquired either by a subject exercising his inherent rights under customary law as a subject, or it can also be acquired by a stranger. So if it's been acquired by a subject who is exercising his inherent rights under customary law, then that subject, we are told under section 5 of section 1, that he must reduce an unappropriated portion of land in his possession. He can get it that way by just moving into an uncultivated portion and reduce it into his possession, or he can go for an express grant. So the subject under section 5 of section 1 can acquire the usufruct in 2 ways, either by exercising his inherent right under customary law to reduce an uncultivated portion of the land and cultivate it, or he can acquire it by way of an express grant from the stool. And then also we are told that under section 5, subsection 1b, the usufruct can also be acquired by a stranger who has stayed on the land with the permission of the holder of the allodial title and has been there for a period of not less than 50 years, and he was a non-indigent. And we are told that the usufructuary interest is inheritable and it is alienable. And remember that we are told that when the alienation of the usufruct is to a person who is not an indigent, then the alienation must be done with the consent of the holder of the allodial title. We shall then move on to the next interests, having discussed the usufructuary interests. And we shall now discuss the leasehold interests. The leasehold interests. Now, for the leasehold interests, it is good that I begin the discussion with the case of Nana Bediako Atre. Nana Bediako Atre, substituted by John Kwame Owusu, versus Osei Owusu. Nana Bediako Atre. Bediako is spelled B-E-D-I-K-O. Atre is spelled A-T-W-E-R-E. Nana Bediako Atre versus Osei Owusu. Civil appeal number J4/36/2010. And the judgment is dated 18 May 2011. In this case, we were told that a leasehold interest is a creation of the common law and not customary law. So this case tells us that if you hear anything like leasehold interest, the leasehold interest is not known by customary law. Customary law doesn't know anything about leasehold interests. What we know under customary law is customary law freehold, customary tenancies. We know usufruct, but we don't know a leasehold interest. So in Nana Bediako Atre, they are told that a leasehold is an interest that is a creation of the common law. But now, under section 6 of our Land Act of 2020, Act 1036, we have also made provision for the leasehold interest in our statutes. Now, under section 6, this is how a leasehold interest has been explained. And I quote, a lease is an interest in land for a duration which is certain or capable of being ascertained. B, arises when a person who holds an allodial title, customary law freehold, common law freehold, or usufructuary interests, conveys to another person an interest in land for a specified term subject to terms and conditions. C, may in the case of a sublease or an assignment arise when the holder of a leasehold interest grants a sublease out of that interest or assigns that interest. And D, does not exhaust the interest of the grantor in the land. And the quote ends. What do we get from the leasehold interest under Section 6 of the Land Act of 2020, Act 1036? We know that one, if you compare the leasehold interest to all the other interests we looked at so far, if you compare to the allodial interest, the customary law freehold, the common law freehold, the usufructuary interest. If you remember, all of these, that is the allodial title, the customary law freehold, the common law freehold, the usufructuary interest, all of these are of indefinite duration. They can exist in perpetuity. They can be held forever. They are not constrained by time. They are not of limited duration. The allodial title, the customary law freehold, the common law freehold, the usufructuary interest, they are not constrained by time. But when you come to the leasehold interest, look at Section 6A. It says that it's an interest in land for a duration which is certain and capable of being ascertained. And we are also told under 6D that it does not exhaust the interest of the grantor in the land. It means that for leasehold interest, you can grant it only for a limited time. You can grant it for 50 years, for 40 years, for 30 years, for 20 years. We must be able to ascertain the duration. That is the defining characteristic of a leasehold interest. And then, having explained the leasehold interest under Section 6, that we are saying that it can be carved out of the allodial title, it can be carved out of the customary law freehold, it can be carved out of the common law freehold, it can be carved out of the usufructuary interest for a specified time, subject to terms and then conditions. That is the leasehold interest under Section 6. And then we come to the customary tenancy. Customary tenancy has been explained under Section 7 of the Land Act of 2020, Act 1036. And how does it explain a customary tenancy? And I quote, a customary tenancy is an interest in land which is created by a contract. B, it arises where a stool or skin or clan or family which holds the allodial title, or a person who holds a customary law freehold, a person who holds a usufructuary interest, enters into an agreement with another person to grant that other person an interest in land upon agreed terms and conditions, and may involve the payment of rent, the sharing of the produce of a farm, or the physical partition or severance of the farm or land. And so, for the customary tenancy, the very common type that we have under our laws is the sharecropping tenancy. Sharecropping tenancy. And over here, we have two categories. either the Abusa tenancy or the Ebunu tenancy. Abusa, A-B-U-S-A tenancy, or Abunu, A-B-U-N-E tenancy. So let me briefly explain these two types of customary tenancies. And I shall begin with the Abusa tenancy. Now for the Abusa tenancy, it arises in situations where the owner of the land, this owner of the land grants land to another person, let's say the farmer, and the farmer will then cultivate the land and plant his own crops with his own money, with his own labor. He plants the land, and then when the produce is ready, then the landlord or the landowner, the landlord will be given 1/3 of a share in the produce of the farm or the proceeds realized from the sale or produce of the farm. And so for the Abusa, once I am the landowner and I give the land to you, and then you go ahead and you cultivate the land at your own expense, when the produce is ready under the Abusa tenancy, you come to me, the landlord, and you give me 1/3 share in the produce of the farm, or you give me 1/3 share in the proceeds realized from the sale, or you give me a 1/3 share of the produce of the farm. That is the Abusa tenancy. And then for the Ebunu tenancy, A-B-U-N-U tenancy, in this case, the owner already has his land. The owner has already cultivated his land, planted his own crops. Then he gives out the land to a tenant farmer to plant and to maintain it. So the tenant is there just to maintain the farm. Now, when he maintains the farm and we have the process of the farm are ready, then what happens? Then the two of them will share it equally. So for the Ebunu tenancy, in this very pristine form, the owner of the land has already cultivated it. He already has his crops. Then he gives it to a tenant farmer to plant and to maintain it. Or maybe he has a land that is bare. Then he gives you, the tenant, financial assistance. So I have my own land. It is bare. Then I bring you the tenant farmer here. Then I, the owner of the land, I give you financial assistance for you to cultivate a farm on the land. In this instance, you realize that the tenant farmer has not expended his own money to plant the crops. The owner already has his crops on the land, and he brings the farmer to come and maintain it. Or the owner has a bare land, and he gives you the tenant farmer the money, financial assistance to plant and to maintain it. In this instance, the proceeds from the farm will be shared equally. That is for the Ebunu tenancy. So what we have done so far is that we have explained in this lecture the usufructuary interest under section 5. We have also explained the leasehold interest under section 6. And we have also explained the customary tenancy under section 7. Now, at this point, it means that we have discussed all the 6 interests in land that have been mentioned under section 1 of the Lands Act. You remember that in our first lecture, we discussed the first 3 interests. We discussed the allodial interests, we discussed the customary law freehold, and we discussed the common law freehold. And in this lecture, we have gone into detail to discuss the usufructuary interests. We have distinguished how there is a subject usufruct and there's a stranger usufruct. We have also mentioned and discussed a leasehold interest, where we said that the leasehold interest is of a definite duration. And we have also discussed a customary tenancy, which we said can either be the Ebunu or Ebusa. So we have 6 interests in land, as I mentioned under section 1. And remember that under section 81, they are all registrable interests. So at this point, we know all the interests in land that can be registered in Ghana. But to introduce you to the next topic we shall discuss, which is the incidence of these respective interests. When we use incidence, we mean the bundle of rights and obligations that attach to all these respective interests. And so if you take the allodial interest, what are the bundle of rights that are attached to the allodial interest holder? When you take the usufructuary interest, what are the bundle of rights and obligations that attach and form a part of the usufructuary interest? When you take the common law freehold, what are the bundle of rights or what are the incidents of that particular interest in land? Section 8 is the point that will let you know how we can determine the bundle of rights that accrue to the allodial holder, the bundle of rights that accrue to the usufructuary holder. Section 8 will give you a good indication. Section 8 says as follows, and I quote, that the bundle of rights and obligations that attach to and form that attach to any form of interest in land shall be determined by the applicable source of law, which is the basis of that interest. It shall be determined by the applicable source of law, which is the basis of that interest. And so if you remember, for example, when we were dealing with the common law freehold, you remember we mentioned that it is an interest in land which arises out of a transaction under the common law. It means that if you want to identify the bundle of rights that attach to the common law freehold, it means that you must go to the common law to determine the bundle of rights that accrue to the holder of the common law freehold. Again, you remember when we were dealing with the customary law freehold, we said that the customary law freehold arises from a transaction under the customary law, meaning that it is that customary law which will determine the bundle of rights that will attach to the holder of the customary law freehold. And so the incidence of the respective interests that we have in land. And when we say incidence, we mean the bundle of rights that attach to the respective interests. This bundle of rights that attach to this respective interest will be determined by the applicable source of law, which is the basis of that interest. So when you take customary law freehold, the source of law, which is the basis of the customary law freehold, is the customary law. Meaning, if you want to know the bundle of rights that attach to the customary law freehold, you must go to the customary law to determine the bundle of rights that attach to that particular interest. So in our next lecture, we shall look at the incidence of these respective interests in land that can be held in Ghana. This is where we'll bring our lecture to an end for this section. Thank you.